Welcome everyone, this is Amer Mushtaq from U-Counsel. Sometimes you receive pleadings from the other party which contains certain allegations that you're not really clear about. You don't quite understand exactly what the other side is alleging. Since you don't understand what is being alleged, it is very hard for you to respond to it. So in those circumstances, you can actually ask the other side to provide particulars. And how do you go about doing that? We will explain that in this lecture. We begin with our usual disclaimer that this course and lecture is not a legal advice. It is only for educational purposes. But if you have any specific questions about your case, you should contact a lawyer or a paralegal or contact the Law Society of Ontario for a referral. Now, we'll begin with the basic rule of all pleadings, which is contained in Rule 25.06 sub 1, which essentially says that the pleadings, whether it's claim, defense, or reply, or cross-claim, should contain concise statement of the material facts. Let me take you to the rule that we can follow, 25.06. By the way, if you're drafting pleadings, it is very important for you to review this rule in detail because it applies to what kind of content you can provide in your pleadings. So 25.06 sub 1, every pleading shall contain a concise statement of the material facts on which the party relies for the claim or defense, but not the evidence by which those facts are to be proved. We'll talk about the rules of pleading in a separate lecture, but for today's lecture, we're focused on a concise statement of material facts. So when you're drafting a pleading, you have to specify each fact that you're relying on to support your case. And a lot of times you get pleadings that contain allegations which are bald or vague allegations, and they are considered improper pleadings and they're problematic. But if you are faced with allegations that are improper or bald allegations, then how do you deal with those allegations and how do you respond to those? Let's take an example of a bald allegation, and then we will explain how to deal with that specific allegation. So in an employment law context, let's say that the statement of claim alleges, there's one fact that it alleges that in the last 2 years, the plaintiff's manager frequently harassed him. So there are 3 things that I've underlined. 2 years, so it happened in the last 2 years. And the plaintiff's manager frequently, how do you define frequently? How many times did it occur? When did it occur exactly? And harassed the plaintiff. So what did the manager exactly do? So this is a very broad, vague allegation. And if you're faced with this allegation, you actually don't need to respond to it because you don't know the particulars of this very allegation. So how do you respond to a bald allegation? I can suggest 2 ways. There could be 3 ways or more, but two ways that I can suggest. One is that you basically ignore the allegation. So how do you ignore it? You respond in your defense or reply or whatever document pleading you're preparing, something to this effect. You don't need to copy it exactly, but something to this effect, that the plaintiff has failed to provide the particulars in paragraph so-and-so, so they have not provided it, the plaintiff has not provided it, and in the absence of which the defendant is unable to plead over. You're basically saying to the court, because I don't know what the allegation is, I'm unable to respond to it. And so if the plaintiff provides me with a specific allegation, I will respond to it. So this is sort of a broad response to a broad allegation. There is a sweeping statement that says, the manager has harassed the plaintiff in the last 2 years frequently, and your response is, that's not correct. We deny the allegation, but we are unable to plead over because we don't know the specifics of that allegation. Or the second thing you can do is that you can demand particulars. So before preparing, drafting, or serving your responding pleading, you can ask the plaintiff in this case, or the other party whose pleadings are vague, that I want you to provide me the particulars of this allegation, because once you provide me the particulars of this allegation, then I will be able to respond to it. So you can ask for it, and demand for particulars is dealt with in Rule 25.10. And if we scroll down to 25.10, here you go. So where a party demands particulars of an allegation in the pleading of an opposite party and the opposite party fails to supply them within 7 days, the court may order particulars to be delivered within a specified time. So when you serve a demand for particulars, then the other party has 7 days to provide you the particulars. If they don't provide you the particulars, you can bring a motion in the court and get a court order to compel the other side to provide you the particulars. You can also bring a motion to strike, because if the allegation is vague and does not contain any specific allegations, you may ask the court to strike that allegation outrightly if the other party is not providing the particulars. So you can demand for particulars in this instance. And so what would you do? You will prepare a document called Demand for Particulars. Just that will be the heading. And you can say something to this effect: provide the date and time of each alleged instance of harassment in the last 2 years, right? This is important. Like, you want to know each instance that the plaintiff is relying on in support of the allegation of harassment. Because if you're aware of each instance or allegation of harassment, then you can respond to it. You can say on such and such date, when the plaintiff is alleging that the manager harassed the plaintiff, the manager was on vacation, for example, right? Or the manager did not do it, or whatever the issue was, whatever the fact that you may rely on in response to that. You can also say, provide me the particulars of the alleged acts of harassment. So what exactly did the manager do? Because when the plaintiff is using the word that the manager harassed the plaintiff, these are words of judgment, right? This is something that the court is going to determine based on the very specific act that the plaintiff is alleging. So what exactly did the manager do? If the manager only asked the employee or the plaintiff to complete his or her work within the deadline that has been assigned to him or her, that may not amount to harassment, right? But at the same time, if the manager used an F word in correspondence with the employees, that may amount to harassment. So exactly what happened? What was the instance? What was the alleged act? If you're responding to it, you are entitled to know that, and then you provide your position. So why this discussion is important is because in our everyday life, whether it's politics or media or our social life, it is not uncommon that we make these sweeping statements about something or about someone, right? So that person does this all the time, or this has been happening to me all the time or frequently, and we make these judgments, right? But in a court of law, that is not acceptable. You will have to provide every single fact on which you are relying on, and then you will have to prove your fact. So an analogy for building a case in court and demonstrating your merits of your case could be like building a house. So imagine that each fact is a brick that has to go in the wall. And so you have to present each fact on its own clearly, and you have to provide the evidence to prove that fact. And once that fact is proven, it goes in the wall, right? And if you're not able to prove a fact, then it wouldn't go in the wall. And that's how, on a brick-by-brick basis, on a fact-by-fact basis, you're hoping to construct a case that demonstrates that you are entitled to the remedy that you're seeking from the court. So that's why it is important for you to, when you are drafting pleadings, to be clear and concise, and sometimes to be vague if that is a strategy that you need to adopt in your particular pleadings. And I have drafted oftentimes pleadings that have contained indeed vague and bald statements, and they served a particular purpose. So it's all part of a larger strategy. Sometimes you want to create a narrative based on all these bald allegations, even though the very material or true allegations are few within your pleadings, but sometimes that's a strategy that you want to adopt. And if you are faced with a similar strategy, you want to be capable of understanding what the other side is doing to you and then defend yourself properly. So in conclusion, what I want you to understand is that this demand for particulars is an important tool in your fight in a court action. Why? Because it allows a party, it allows you to understand clearly the allegations that you have to defend. Because if the allegations are not clear, it will be hard for you to defend yourself, and you don't want to be defending yourself on bald and vague allegations. The other thing it does is it restricts the other party from creating an unfavorable narrative based on unspecified allegations, right? So the other party may use this, as I said earlier, to create a narrative, repeated words, constantly, every single paragraph, the party is repeating that the manager has been harassing, and the manager has been harassing other people. That may not be even a relevant pleading. And the manager did that in the previous job. All of these things may not be the material facts that the party could rely on in a court action. But with respect to the specifics, if you don't ask for it, you may unwittingly and not recognizing that the other side is actually creating a narrative against you, which they are not allowed to do based on the rules of pleadings, right? So you can challenge that. And then also, once you demand for particulars, you force the other party to limit its case to specific allegations, right? That's what the case is going to be fought on, the very specific allegations that are being made, that you are making in your pleadings, and then the court needs to determine whether those factual allegations are true, and in the end, whether those allegations support legally the case that you are pleading before the court. So hopefully this explains to you how to effectively use demand for particulars and how to respond to those. Thank you for watching, and I look forward to seeing you in the next lecture.